a lot of online entrepreneurs, I see them talking about legal stuff. They're talking about copyright. They're talking about trademark. They're talking about this, that, and the other, but they don't have their basic agreements in place. And I'm here to tell you, as a lawyer, a guy who, went to Harvard Law School, so I know these things, but also as an entrepreneur who kind of made one of these mistakes early on, what I can tell you is that getting your agreements in writing is the most powerful thing you can do to avoid legal problems down the road. Welcome to the Certified Badass Online Marketing Podcast, where being a badass has less to do with what you wear and what music you listen to, and everything to do with whether you've got the thriving online business of your dreams. I'm your renegade thinking Harvard Law grad turned online entrepreneur host, Bobby Klink. In my years building my thriving business, the most important lesson I've learned is that being a badass online marketer isn't about secret strategies or ninja tactics. It's about doing the basic stuff right and showing the F up. So each week here on the show, you'll get clear, easy to execute guidance on how to build your online business and a swift kick in the ass or two to make sure you're getting it done. Hey there, welcome to episode 170 of the Certified Badass Online Marketing Podcast. I'm your host, Bobby Klink, and I am really excited for today's show because we're getting back to basics. We're going to talk about something that kind of is where I started in this whole business. We're going to talk about some legal stuff. But don't worry, I'm not going to make it boring. I'm not going to read you some involved treatise about the legal stuff because nobody wants that. But today we're going to talk about the most powerful tool you have in your arsenal to protect your online business, and that's about getting it in writing. And specifically, I'm going to tell you the 5 types of kind of written policies or agreements that online entrepreneurs need to be focused on. So that's what we've got in store for today. I'm going to make this quick, easy, understandable, and step by step so you can understand the legal stuff you need to protect your business. Now, before I dive in, this episode is brought to you by my signature legal template product, my Online Genius template library. If you don't know the template library, it is the all-access pass to my legal templates. You get every single legal template I sell, plus any that I add in the future, you'll get those too. And it's not a membership, so you don't have to keep paying forever and ever and ever. You buy it once and you have it forever. And so that's what the template library is. It's meant to be something so that online entrepreneurs can buy their legal toolkit they need now and have it without having to worry going forward. And if you're listening to this live or in the month it came out, here in August of 2020, we're running a special promotion. Anyone who buys the template library this month is also going to get access get a free VIP ticket to my upcoming live event. Now, if you're sitting here thinking, Bobby, the last thing I want to do is go to a live event about the legal stuff, don't worry, I wouldn't do that to you. We are holding an event called Badass Online Marketing Live. It's going to be a virtual live event because, stupid COVID, but we're going to be doing that later this fall. It's going to be all about how to build the business of your dreams, not my dreams, not anyone else's dreams, but how to basically build a business that is kind of the business you actually want, but also a business that's suited for the long term. In other words, how are we going to kind of create it, or how are you going to create a business that's sustainable, that isn't kind of subject to all of kind of the down cycles and all of the different problems you could have in kind of the online marketing world that we see so many people have. So that's what the event's going to be about. You're going to get a ticket absolutely free if you grab the template library this month. So if you're interested, head over to bobbyklink.com/template library. Again, bobbyklink.com/template library, and template library is all one word. Head over there and you get all the details. Now, with that, I want to dive into the topic of getting things in writing. And I want to talk before we give you kind of the 5 types of agreements or categories of agreements you need to have in place, I want to talk about the importance of this because a lot of online entrepreneurs, I see them talking about legal stuff. They're talking about copyright. They're talking about trademark. They're talking about this, that, and the other, but they don't have their basic agreements in place. And I'm here to tell you, as a lawyer, a guy who, went to Harvard Law School, so I know these things, but also as an entrepreneur who kind of made one of these mistakes early on, what I can tell you is that getting your agreements in writing is the most powerful thing you can do to avoid legal problems down the road. And I could tell you this partly by giving you kind of my origin story here, which is that when I started my online business, at that point, I had a law firm, my own law firm, Clink LLC, which I'm really trying to wind down. We've been trying to wind that thing down forever. I've got one little tiny case still going. But the story behind how that law firm started is interesting because I didn't intend to start my own law firm. I never did. Coming out of a job, after I'd been a lawyer for, 8 years or so, I was coming out of a job as a federal prosecutor, which I loved. And I joined this small entrepreneurial law firm here in Washington, D.C. And we kind of did it on, it was two guys who had a partnership, and I just kind of joined them, and we had a handshake deal, and everything was good. Obviously, they weren't going to bring me in as a partner at the beginning. You don't normally do that in a law firm. And we didn't ever put anything in writing about what that was going to look like. How would I eventually become a member, a partner, kind of a full equity stakeholder in the business? Well, we didn't do that. And I have to say, I was at that firm for almost 4 years, I think, 3 years, 9 months, something like that. And they treated me fairly the whole time. We were splitting the revenue, not exactly one third, but pretty darn close. And, I was always happy about it. Now, part of what you need to understand about that firm is that kind of like most entrepreneurial ventures, there was not consistent revenue. Like we were doing cases that were on contingency, so we would get paid when we won. We wouldn't necessarily get paid month in and month out. And so I had all the downside risk. In other words, if the firm didn't make money, I wasn't getting paid. And while I was there at the firm, I was treated completely fairly. I was participating in the upside. Then my wife got pregnant with my daughter. And at that point I said, hey, right now, from a legal perspective, I have all the downside risk because if the firm's not making money, I'm not making money. But if we hit a huge payday at that firm, and we had some cases that potentially could have done that, I wasn't guaranteed anything. Now, they had treated me fairly, but you can imagine all of a sudden when I have a daughter coming into the world, I wanted a little more protection. And so we tried to talk about it. And we started a conversation, and we kind of couldn't come up with anything quickly. Things came to a head when my daughter was 3 months old, and we had a series of conversations that went from Friday to Sunday. And that Sunday night, it was snowing. I remember that. Here in Washington. It was a good thing this call was a conference call because I probably would have thrown something at one of the guys if we'd been in person. And again, he wasn't, being mean. It was just we were having this discussion and we couldn't come to an agreement. I literally was holding my 3-month-old, looked over at my wife, and my brother-in-law was there. I don't remember why my brother-in-law was at my house, but he was. I said, we got to go to the office now. I went and I dropped off all of the things I had that belonged to the firm and picked up all my personal effects. The saddest part about that, so from a financial standpoint, it ended up not being the worst thing in the world. It set me on the path that I'm on today, so I'm happy. But again, I'm generally not someone who has regrets. But there were some emotional issues of it. Like the guy that I said I would have thrown a mug at. That was a guy who had flown through Hurricane Sandy, literally gotten on a 10-person plane in Florida to fly through Hurricane Sandy into the Bahamas for my wedding. I haven't talked to him since 2014 because of this blow up. And so I understand that this stuff, a lot of times you're like, oh, come on, they'll be fair. And everybody is being fair and you don't have any concerns until you do. And the problem is that what I've seen is when people don't get agreements in writing, it can blow up in your face if things go poorly, and it can blow up in your face if things go great. And I've heard so many other big time entrepreneurs talk about how they had similar things happen, like as they were getting the online space. They kind of did a partnership or were working together with people with no written agreement. And then the person with all the money and all the power just said, bye-bye. So it happens. So what I want to stress to you is that as you're building your online business, the most important thing you should do to protect your business is to get your agreements in writing. And the simple rule I tell people is every agreement should be in writing. Any agreement that is important to your business, where if the other side didn't live up to that agreement, you should have it in writing. So that basically means every relationship, every contract, kind of every kind of deal you do should be reduced to writing. Now, I'm not going to talk more about why it's important. I think I've talked about it before, and I'm happy to answer questions if people have it. You can reach out to me on the socials. We can chat about it. But now I want to dive into kind of the 5 different types of agreements that you need to have in place. And the first is I'm tricking you here a little bit because these are policies more than agreements, but it fits. And the first group are your website policies. These are the boring things that we all link to in the footers of our website: your privacy policy, your terms of use, and your disclaimer. Now, some people will combine the disclaimer and the terms of use into one document. That's fine. I just like it separate because my mind likes things separated into chunks. Basically, one of those documents is required. If you're an online entrepreneur, you're required to have a privacy policy on your website. Now, some people get mad at me for my Facebook ads. No, you're not required unless you're collecting data. Well, if you're an online entrepreneur, you darn well better be collecting data on your website. And just so you know, the laws that apply, like even if it's just Google Analytics or Facebook Pixels or things like that, most lawyers agree that those things require you to have a privacy policy. There's a California law, there's a European Union regulation, there's some other laws that apply, some other countries have passed laws. So, you just got to have a privacy policy. And this basically tells people, what do you do with their information? I mean, what do you collect? Why do you collect it? What do you do with it? What protections do you have in place? The basic information. The interesting thing is this document, even though it's legally required, is often the least kind of legally sounding document of all that we're going to talk about. Now, it's often kind of technical because you'll talk about things like cookies and data and pixels and things like that, but it's not legal sounding. You're basically telling people all this information about their policy. Now, like I said, that is the only thing we're going to talk about today that is legally required. That's why I give it away. That's why that's been my freebie forever. So I don't believe that online entrepreneurs should be required to pay to comply with the law on this one thing. So that's why I've made that my freebie. If you don't have it yet, you can head over to bobbyklink.com/PP and you can get my free privacy policy. So you've got that taken care of. So that's the one that's required. The other 2 are your terms of use or terms of service, it'll sometimes be called, and a disclaimer. Your terms of use is basically the basic rules of the road. So it kind of is an agreement. It's an agreement between you and your website visitors, but candidly, unless you get them to affirmatively click to agree somewhere, they're going to say, well, I didn't agree to this, so you can't force me to comply with it. And they're probably right on that. But it's setting out basic things. But there's some important things you're going to put in here. This one is a big, ugly legal document. I think my template is, 13 or 14 pages long in Google Docs. And it's got a lot of big, ugly paragraphs that you don't want to read. I don't want to read. No lawyer really wants to read, but we've got to put in there. But some of the more important things, it'll put things like your basic refund policy. So like if you sell like little things on your website, like individual templates or individual little low price things, you're not going to have a separate agreement that people agree to every time they buy one of those, but you could just have them click to accept your terms of use more generally, which has a basic refund policy or basic no refund policy, whatever your policy happens to be. Now, this is not for your course. This is not for your membership. This is not for your signature product. This is just the background rules. Then you've got your disclaimer. And this is one that, who knows how effective it is, but this is basically a document that everyone should love. It should be your favorite policy or agreement that you have. Think of it as your get out of jail free card, kind of in Monopoly, if you remember that. It is a document that says you can't sue me because. And it has a bunch of different reasons. You're saying, among other things, I'm not giving you professional advice. I'm giving you information and education on this website. You say things like, I did my best to ensure the accuracy of things here, but I can't guarantee the accuracy of things. I've got links to third-party sites here. I definitely can't guarantee the accuracy of those. You take full responsibility for whatever you do with the information I provide, and a bunch of other things like that. So it has a lot of that language and then other things. So that one you should love. You should definitely have that in place. So those are the first category, website policies, your privacy policy, your terms of use, and your disclaimer. That's our first category. Now let's move to the next category. And now for the rest of them, these really are agreements. The next category we're going to talk about are client agreements. And this is for any kind of one-on-one work you do with people. It could be if you are a service provider, if you're a coach, if you do VIP days, if you do anything like that, you need to have a written agreement that sets out the basic terms of what they're going to get and what they're going to pay. And there's other stuff you put in here. You put in things like, how do you resolve disputes? And, you deal with the copyright issue, like who owns the work product and all those kinds of things. But at the end of the day, the most important piece here is to be absolutely crystal clear about what they get and what they pay and then when. And so what I mean by that is that you need to be very clear about, like, especially if it's project based. Now, if you're doing hourly work for someone, it's not as important, right? If you are doing work by the hour and they're going to pay you for the work you do on an hourly basis, that's what you're agreeing to. You're agreeing to do that, and then you have to set out when they're going to pay you. Is it before? Is it after? Etc. But if you're doing more of kind of a lump sum, like I just did a VIP day with someone, and I put out there that we're charging $4,000 for this VIP day. Well, you need to have an agreement that sets out, okay, it's $4,000, and here's what you get. Now, in that case, it was largely about a block of my time and my team working with you. But it could be that if you're a website developer, you say, well, I'm going to build your website, and I'm going to charge you this much, and you lay out what it means to build your website. Be specific here. So it could be that you're going to build it on WordPress, including, checking for all conflicts, making sure it's picture perfect, building X number of pages, etc. You're going to lay all of that out in detail. So there's just no question. If you're a copywriter, here's a great example. You're going to include in the contract, if it's like a lump sum payment for a copy project, you're going to say, do they get revisions? If so, how many? You have to put all of that in there so that there's no question, because you don't want scope creep, right? You don't want, like if you're a copywriter as an example, you don't want your client coming back for that 8th round of revisions because they believe they're entitled to it. And I've seen people who, like copywriters, who had this thing that said, like, we guarantee your satisfaction. Like they had that in their contract, but they're like, oh, but we don't do revisions. I was like, well, if you guarantee their satisfaction and they say they're not satisfied, you kind of did. So you've got to be careful. And the concept of this, when you're laying out what they get, is to be so specific so there just isn't a question about whether you performed or not. You don't want there to be a debate about, well, you said you would provide marketing services, and what does that even mean? No, you want to say, I will do these tasks. And if it's like a recurring role, like I had this originally when I hired my very first VA, who was basically a social media VA. And, she laid it out very specifically that on a monthly basis, she would do these tasks. On a weekly basis, she would do these tasks. And on a daily basis during the week, she would do these tasks. And so it was very specific. There was no question. You knew exactly what the deal was. So there was no question. Now, then the other piece is what they get paid and when. Or what you get paid and when if you are the service provider. So you need that set out there. Just again, there's no question of it. Is it all up front? Is it 50% up front? Whatever it is, just lay that out in the agreement. Now, the other type of kind of service agreement or client agreement is a coaching agreement. And with a coaching agreement, it's largely the same thing. You're going to explain what they do. You're also going to have a little more of that disclaimer language that this isn't a substitute for professional advice, etc. And you're going to have things like cancellation, like when are they allowed to cancel? What happens? Like, do they have to cancel 24 hours in advance of a call, 48, 72, whatever it is? Because you don't want people canceling a call like an hour before your coaching and then expecting a makeup call, right? Because you've already blocked out that time. So you have to lay out all those kinds of things in there. So that's client agreements in a nutshell. The next category, so the third category of agreement here, is a program agreement. And these are similar to client agreements, but for a one-to-many program. The most obvious examples are an online course agreement and a membership agreement. They're similar, but slightly different because of the nature of the thing. And the way I think about it in my mind, pretty much all program agreements are either kind of a course agreement or a membership agreement. The difference is it a set payment? And even if there's a payment plan, but literally they pay, $1,000 for it, or let's say 12 payments of $100, or is it an ongoing recurring payment until canceled? If it's an ongoing recurring payment till canceled, it's a membership. Otherwise, it's a course. So that's kind of how things are going to break down here. And in these agreements, what you're going to lay out is what they get. Again, what are the core elements of the course, the agreement, or the program, et cetera. So it could be, a 7-module course, a Facebook group, coaching calls, whatever it is, but be specific and be careful about, like, if you are doing Q&A sessions, of telling them either how long they will have access or how many total they will get. Now, you can always give them more, but if you don't have that, if you say, like some people say, you will get lifetime access to the course and a Facebook group, and then they say, and I do weekly Q&A calls in the group. Well, that person has then basically committed themselves to continuing to have this Facebook group and continuing to do weekly calls. So instead of that, you want to say that, you'll have access to a group and I do question and answer sessions, and you will be entitled to at least 3 question and answer sessions, or 7 or 12 or whatever the number is. That way you can keep doing it if you want to do more, but you also then know that you could stop doing question and answer sessions when you stop selling the product after a certain period of time. So like if you guaranteed them 12 and you're doing them weekly, okay, if I stop selling the product today, I have 3 more months of Q&A sessions I have to do. So you want to put a cap on those kinds of things. Now, bonuses are tricky because there's no way that you want to put in all the different levels of bonuses, which, I don't know about you, but when I'm in the middle of a launch, when I do launches, I will sometimes randomly decide on another bonus in the middle of a launch. So you don't do that. You'll have a clause in there that says that they're entitled to the bonuses that were advertised at the time of their purchase. It's not ideal, but that's the best we can do in this one-to-many experience. But so you lay out that, again, what are they going to get? What are the contours of the entire program? And then what are they going to pay? And part of what this sets out with your course agreement especially is, if they pay you up front, it's not a huge deal, right? They paid you. But if they're on a payment plan, this agreement is what gives you the permission to continue to charge them throughout that payment plan. So if you get some kind of credit card dispute or something like that, you can present this and say, hey, they agreed to this. This is what they agreed to, and they authorized me to make these charges. So you want to kind of have that in place as part of your sales process. Now, you're also going to have your refund policy in a course agreement, whether it's no refunds, no questions asked refunds for a certain period of time, or a show your work refund policy. Whatever it is, lay it out and be specific. Now, it's not hard to be specific with a no refunds or no questions asked for 30 days, 90 days, whatever. Where you have to be really specific is the show your work. Kind of like I mentioned with client agreements, here on this refund policy, you want there to be no question whether someone is entitled to a refund. And so you should lay out what work do they have to show, what are the requirements, how do they do it, etc. So there's just no question. You can look at it and say, yep, they showed me the work, so they get it, or no, they didn't, so they're not going to get it. And that's what you want with your refund policy. So that's your course agreement. There's other stuff in there, but those are the core pieces to it. Now, a membership agreement is going to be similar because it's going to lay out what they get, what they pay, but most memberships don't have a refund policy. Now, if you have one of those annual memberships where people can get a prorated refund if they cancel during the year, that has to be in there. But you've also got to have the cancellation policy. You have to tell them in that agreement, how do they cancel? Who do they email? What do they do? How does it work, etc. So that's kind of the slight difference between the two. And you have to have that piece in place. Now, with both of these, and you would do it with a group coaching program, etc., or anything similar, you would have an agreement like this. During the sales process, as they're checking out, you want to make them click a box to accept the terms and conditions of the course, the membership, etc. How you do this is going to depend from your checkout, kind of your cart software, but you need to have that checkbox because that's proof that they agree to it, and they can't then say, well, I never agreed to this. Yeah, you did. You checked a box. It was required. That's the only way you were able to check out. So that's what you're going to do there. Now, that's the third category of agreement. The next category of agreement we're going to talk about are team agreements. If you have a virtual assistant, you need a written agreement with that VA. If you have any contractors working for you, you need to have an agreement with those contractors. If you have employees, you need to have an agreement with your employees. And employees are slightly different. We'll talk about that in a second. But for like a VA and a contractor, again, it's what work are they performing for you? What are they getting paid? And here's a few other things you need in there. Number one, you want something in there that you own the work product, that they are transferring any right to the copyrights, et cetera, to you. So you own it. So there's no question about that. And then a confidentiality agreement. You don't want contractors taking the information they learn from you and then either going and starting their own business or using it to help competitors or anything like that. So you'll have that in it. Now, I want to be clear. Some people ask me this question. Well, if they give me their agreement to sign, do I then need to have them sign my agreement too? No. You don't need two agreements. If your VA that you're hiring has a standard agreement or a contractor has a standard agreement, that's cool. Just make sure that it's specific about the work they're going to provide for you, specific about payments, when payments are due, and specifically has those things, the transfer of copyright and confidentiality clauses. As long as the agreement that you sign has that, you're good. So if they have one, great. But a lot of times they're not going to have one. And so you want to have that in your back pocket. Or I've seen contractors who will send me something. It's like this one-page agreement that doesn't have this stuff. I was like, oh no, I'd rather use this one instead because it actually sets things out in more detail. So that's what you need. Now, employees, employment law is governed by state law. So you're not going to, I can't go into all the details. Normally here in the United States, you are not required to have a written employment agreement. But just like with contractors, there's a few things that you want to have in place at a minimum, a transfer of copyright and a confidentiality agreement. You want your employees to sign on to that. So there's no question you own the stuff. You probably do anyway, but you just don't want to question. You want no dispute about it. And then also that confidentiality. You don't want them coming to work for you, taking everything they learn and then starting a competing company. With your internal systems and all your confidential information. So those are things you need to have in place as well. So those are team agreements. Now that brings us to the final area of agreements. The final category is generally what I would call publicity releases or publicity agreements. Think of this as a broad category that says if you are going to feature someone else or someone else's product, is going to be included in your platform and what you're selling and your commercial activities, you need releases. So there's a few places this comes up. If you're going to have a guest teacher come into your course or your course or a membership, like if they're literally contributing something that goes into your recorded course material, you need to have an agreement with them. Part of what that agreement does is it gives you a license to use the material if it's a pre-existing training, or also you might say, hey, I want you to specifically create this training just for me and it's mine. You can't then sell it to anyone else or use it anywhere else. I own it. So you want to spell that out. You also want to say, what are they getting paid? Hopefully they're not getting paid anything. It's exposure, but you have to lay that out and just all of these other things. Plus get permission to use their name, image, and likeness in your marketing. So you need that from a guest teacher. If you have a podcast, you have guests coming on, you should have them agree to a podcast guest release, which essentially says you as the podcast host own the interview. They don't, but they're transferring any copyright to you. It's really weird. The law is not entirely clear about who owns a recorded material when in an interview. So let's just make it clear. I own it. You're transferring the rights to me. And then also it gives you the right to use their name, image, and likeness in marketing, not just the podcast, but for a broader thing. Like let's say you wanted to do the 10 best pieces of advice entrepreneurs provided on my podcast. Well, there you've got a broad release that gives you the permission to do that. Now, I'm going to be honest with you. Chances that podcast guests are going to be mad and say, no, you can't do that, quite small. But why not do it? Why not have it just so there's no question, no possible dispute? And that brings us to our last kind of example or thing in the publicity release, which is testimonial releases. And this is one, again, I point this out to people and I say, look, let me just be very clear. The chance that anyone who gives you a testimonial is going to be mad about you using it, I don't want to say it's none, but it's next to none. But under the law in certain states, at least here in the United States, if you live in certain states, if I want to use your name, image, or likeness in a commercial way, I am required to have a written release. Now, some states don't require it in writing, but some states do. So rather than look and figure out, well, do I need a written release or not? Just work it into your testimonial process that when people give you that, they give you a written agreement that you can use it and you can use it commercially and you can use it in your marketing. And that will ensure that you are, kind of have the rights to use the testimonial and a dispute doesn't come up. Again, unlikely it's going to come up, but let's just be safe on this. So that's in a nutshell, the 5 different types of agreements you could have. Now, there are some other ones that I could mention, but I said, let's do it in a round number. Let's do 5 and let's make it, easy to understand. So that's why I laid it out this way. If you'll kind of focus on getting these agreements written out and in writing every time, you will be in good shape legally. Now, if you want help doing that, that's where my legal templates come in. And if you go and grab access to my template library, I've got templates for each and every one of these things we talked about and more. And we're constantly adding more agreements. So, you will get access to that. You get access to all of that, all of them for life when you join the template library. And as I mentioned, we're currently running a promotion this month in August. If you join the template library, you will get a VIP ticket to my live event, Badass Online Marketing Live, which is happening this fall. You'll get a VIP ticket for free, nothing extra, just as a little incentive to maybe get you off the fence to decide now's the time to go protect your business with the legal stuff. If you're interested, head over to bobbyklink.com/template library. Again, bobbyklink.com/template library. You can get all the details and just click the button and buy and have your legal protection in place. That's it for now. I'll talk to you again next week. That's it for this episode of the Certified Badass Online Marketing Podcast. Make sure to tune in next time. And in the meantime, go out and build the badass business of your dreams.